Straight ahead on Law&Crime Daily, the Sandy Hook defamation trial.
We gave each other a big hug and a kiss, and I left for work. And can't think of a better way to, if it had to go that way, I can't think of a better way.
Hear emotional testimony from a shooting victim's husband and the North Dakota love triangle trial.
Right to the right of it in the photograph is a big gaping wound. The pellets then actually continued their course through the arm, into the left side of the head, fractured the face, fractured the skull.
Jurors hear from the medical examiner in the murder conspiracy case of Nikki Entzel, plus the Pike County Massacre. Jurors are shown a piece of evidence that helped link the murders to the Wagner family. But first, the courtroom gets heated as Waukesha Christmas parade suspect Darrell Brooks seeks to represent himself.
You are being difficult. You are not listening. You are trying to interject irrelevant factors.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. We begin with news out of Wisconsin, where a Waukesha County judge rules accused parade killer Darrell Brooks can represent himself at the coming trial. Officials say that Brooks drove his vehicle into a Christmas parade last November, killing 6 people and injuring dozens of others. Prosecutors say Brooks did not stop driving even as victims banged on the hood of his vehicle, motioning for him to stop. Now he faces a total of 77 charges related to the incident, including 6 counts of homicide by vehicle, hit and run involving death, first-degree recklessly endangering safety, use of a dangerous weapon, battery, domestic abuse, and bail jumping. Right now, Brooks' trial is set to begin next Monday. Ahead of that, Brooks indicated he wants to defend himself as a sovereign citizen. Things got tense when Brooks appeared in court on Tuesday.
Sir, did you hear me tell you about the penalties for these offenses?
Yes, but I don't understand the nature of the cause of the charges.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Did you hear me tell you about the penalties for hit and run resulting in death?
I don't understand the nature and the cause of the charges.
But that's not my question, sir. So stop playing games with me right now, okay?
Judge Jennifer Darrow did not make a ruling on Tuesday calling for Brooks to meet with his attorneys before another appearance. Wednesday morning, Brooks' mother sent the judge a handwritten note reading in part, quote, "He's not capable of being his own attorney. How can a person who has a mental illness fully understand?" Before Judge Darrow made her ruling on Wednesday, Brooks once again got argumentative as questions were asked.
This trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that. And I object on the grounds that are you making a judicial determination of that when you haven't even decided the issue while we're here?
Sir, I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58. This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Sir, did you hear me just now?
Is that an answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a
Mr. Brooks, we'll move on. You are advised
You are
that,
resting judgment.
Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said that.
There
but
are
you
a
didn't
number
answer
of reasons which I will advise you make it impractical.
You're not
This
answering
trial
my
is
question, though,
scheduled.
Your Honor.
Mr. Brooks, do not interrupt.
That is a resting
Mr.
judgment
Brooks.
if you don't answer the question.
Joining us today is legal analyst Dina Dahl and co-host Terry Austin. Dina, did the judge make the right call? Should Brooks be able to represent himself pro se?
You know, when you okay, every defendant has a right to an attorney, and if they can't afford it, can be appointed to them. They also have the right to represent themselves. But representing yourself means that you have to follow the same rules of procedure, the same rules of evidence that every other lawyer does. Just because you're representing yourself doesn't mean you get a free pass not to know the law. So it's a huge uphill battle, especially in a case like this. And that interaction, it certainly seemed like he wasn't competent to be able to represent himself because he didn't even seem like he could understand, you know, the issues that she was saying there.
Yeah, well, Terry, what exactly is a sovereign citizen? And when he was asked, as we saw just there in a few clips, do you understand or did you hear, do you think that Brooks really understood the charges or was he just playing games?
Oh, he was definitely playing games. A sovereign citizen, it's someone who believes that they're not subject to any sort of governmental law or proceeding unless they consent. So they don't believe in paying taxes. They don't believe that courts have jurisdiction over that. And so he is playing a game here, which is one of the reasons if I had been that judge, I would say you need counsel because she's going to have a trial of the century where it's going to be this back and forth. So he seems like a relatively intelligent guy. He's been involved with the criminal justice system in the past. He understands what she's saying, or he should, because he's been involved before. So he's just making it very difficult for himself and for the court.
It's going to be a very, very interesting trial to watch. Make sure to follow it at lawandcrime.com. And in Florida, the penalty phase trial for the Parkland school shooter recesses because of inclement weather due to Hurricane Ian. The shooter is facing the death penalty or life in prison after pleading guilty to the Parkland school shooting in which the then 19-year-old gunman killed 17 and injured 17 others at Marjorie Stoneman Douglas High School on Valentine's Day in 2018. Following just 2 days of testimony this week, the court decided to close Wednesday and Thursday due to Hurricane Ian, which made landfall in Florida as a strong storm. Friday was already a scheduled day off in the case, so testimony won't resume until next Monday. Still ahead on Law and Crime Daily, we head to North Dakota as witnesses' testimony begins in the murder conspiracy case of Nikki Entzel as she faces trial for her role in the shooting death of her husband. But first, key evidence is shared in court in the Pike County Massacre trial out of Ohio, tying George Wagner IV to the crime scene. Welcome back. Jurors in the trial of George Wagner IV see one of the first pieces of evidence that prosecutors say linked the Wagner family to the murders of the Rodins and Hannah Gilley. Law and Crime's Anjanette Levy is here with images of the evidence.
Well, Brian, shoe impressions were collected from a couple of the crime scenes and then sent to a trace evidence examiner at the state crime lab. Take a look at these. These are the impressions that were collected in blood at the crime scenes. Suzanne Elliott, who examined the impressions, said they were enhanced using chemicals. She couldn't find the tread pattern from those shoes in 2 databases, so she went shopping. Elliott said she went to several stores before finding shoes with the tread pattern at Walmart, in which she called an aha moment. Elliott said the shoe impressions at the crime scenes came from the sizes 10.5 and an 11 size shoe, which were both left at the crime scenes. Now, you may be asking yourself, why does any of this matter? Well, after Elliott identified those shoes as coming from a Walmart store, BCI agents submitted subpoenas to Walmart, to all the Walmarts within a 50-mile radius of where the crimes were committed. They got back receipts and also surveillance video that showed all of these people in that area buying these Walmart shoes. And Angela Wagner, George Wagner's mother, was one of the people buying those shoes days before the murders. She is expected to testify about that later in the trial. Brian?
Thank you, Anjanette. Terry, this almost sounds like a true crime version of Cinderella, but how strong is the connection between Wagner and these shoe impressions, especially when the prosecution has no actual shoe?
Well, you know, it definitely would be stronger for the prosecution if they had those actual shoes. But the jury can connect those dots. If you have the impression, and kudos, by the way, to the agent who found that Walmart footage and who found the receipts, because if you have the shoe impressions and you have the receipts and you have the video evidence of Angela purchasing those shoes, then all you have to do is put it together. Why else would she be purchasing men's shoes in those sizes? So I think the jury, it's like having a gun and bullets and making the dots when you are able to connect that gun to those bullets. When you bought the bullets, you bought the gun, you might not have the gun. But all in all, I think the jury is going to be able to figure it out with or without those shoes.
Yeah, but that's an important part and an interesting part as well, because Dina, this testimony all seems to depend on Angela Wagner testifying, right? So is it smart to stack such an important part of the trial on a cooperating co-defendant?
I mean, normally it's not that smart because they can, the defense attorney can show that maybe the witness, got something in return for their testimony, as here, like some sort of reduced sentence. But the fact is, it doesn't help that this is a family member testifying against the defendant. And I think that goes against the idea that maybe the witness is lying in order to get a lighter sentence, because usually family members aren't willing to testify against other family members. And here you have that.
All right, well, Anjanette, will another shoe impression expert testify at the trial?
Yeah, Brian, his name is William Bodziak, and he actually testified at a hearing pre-trial. It was called a Daubert hearing to determine whether or not this evidence really passed muster scientifically. And he is a really famous guy. He used to work for the FBI. He really wrote the book on shoe impression analysis, and he was the person who tracked down those Bruno Bali shoes in the civil trial for O.J. Simpson, in which he was sued for wrongful death 20 some odd years ago. So he really knows his stuff and is expected to back up the assertions of Suzanne Elliott.
Yeah, it looks like he left a good impression on you, Anjanette. We'll see if he does the same with the jury. Well, coming up on Law and Crime Daily, plaintiffs in the Sandy Hook defamation trial take the stand, saying Alex Jones's comments make them fear for their safety. Plus, graphic photos of the victim are shown in court as the medical examiner testifies in the North Dakota murder conspiracy trial of Nikki Entzel. Welcome back. Testimony begins in the North Dakota murder conspiracy trial of Nikki Entzel, as jurors hear from several witnesses on the first day, including the victim's family members and the medical examiner. Entzel is charged with conspiracy to commit murder, among other charges, for her role in the 2019 shooting death of her husband, Chad. Investigators say Entzel was having an affair with a man named Earl Howard while she was still married. They say in late December of 2019, the pair conspired to kill Chad. Officials believe the motive was money, including a $600,000 life insurance policy and a $26,000 property insurance policy taken out just days before the murder. Howard previously pled guilty to conspiracy and arson charges. Investigators say the pair shot Chad in the head, then days later started a fire at the home, which they believe was an attempt to cover up the murder. The 12-person jury heard key testimony from the medical examiner, who explained there were no signs Chad was alive when the fire started.
So the shotgun wounds that he had, if he would have gotten medical attention, would he have survived those wounds?
No.
Why do you say that?
The injury to the back of the head behind the left ear was completely devastating. It caused multiple fractures in the skull, and it, as I say, severely injured the brain.
Was there a way to tell if Chad died before or after the fire began?
Well, he did not. He died after the fire, or died as the fire was starting, because had he died when the fire was in progress, he would have inhaled smoke, and we've been able to detect soot in his airway. The same soot that was on his body would have been in his bronchial tubes and his windpipe, and did not find any of that.
Terry, how does how Chad dies play into proving this was a conspiracy to commit murder by two people and maybe not just one, which I'm guessing is Entzel's defense?
Well, he died from gunshot wounds to the back of the head. So that means one person pulled that trigger, probably. It was only one type of gun. So I do think it supports what the defense is probably going to say, which is, look, it wasn't me, it was him. And they don't have any evidence that there was a beating with multiple different types of weapons. There wasn't a different type of gun. It was the same type of gun. But even if Entzel is able to say, look, I didn't do the actual shooting, she still has those conspiracy charges. So I don't think that's really going to help her that much. It's just, one thing that she can point to say it wasn't me, it was him.
Yeah. Now, Dina, the ME testified that Chad Entzel could not have survived the shooting, explaining he was shot in the back of the head. Is that fact a win for the prosecution?
Well, it's always helpful to the prosecution when they can so definitively have a cause of death. Because as you see here, there's, the less kind of options that a jury has as to who did it, like Terry was mentioning, if it was her or the other man, that hurts. And then the same with cause of death, whether or not it was the fire, whether or not it was the shooting. So it does help in terms of their theory of the case for it to be definitive as it is here, how he died.
All right, we'll continue to keep track on this case as it progresses. When we come back, the Sandy Hook defamation trial. We head to Connecticut, where jurors will soon decide how much radio host Alex Jones owes in damages. Welcome back to Law&Crime Daily. On day 10 of the Alex Jones defamation trial, jurors hear from the husband of a Sandy Hook school shooting victim. In December of 2012, a gunman opened fire on the elementary school in Newtown, Connecticut. 6 staff members and 20 students were shot and killed. In the years following, right-wing radio host Alex Jones commented on the massacre, saying it was a hoax put on by crisis actors. As part of his second defamation case, 15 plaintiffs sued Jones, saying his remarks led to people tormenting the family members of victims and jeopardizing their safety. Jones has already been found liable for damages in this case, meaning jurors will now decide how much he should pay. On Wednesday, jurors heard from the husband of Mary Sherlock, the school psychologist who was shot 5 times. Her husband, William Sherlock, told jurors he feared for the safety of his family after Jones commented on the shooting.
Did there come a time that you became concerned about your safety and the safety of your daughters and grandkids?
Yeah. There was enough vitriol out there that I was concerned that, well, let's put it this way. Okay, so let's move it back a little bit. The major crime unit from the state police, we had meetings with them periodically. And at the end of the meetings, they would always tell us, be on guard, be careful about what you do, make sure you know where you are, what's going on. It's been constant. I mean, that's never leaves me at this point in time. Always aware of what's going on around me, introduce myself when I'm out and about with people that I don't really know, and it's just my first name.
Dina, we're hearing rumors that Jones won't be on the stand this week, but is his absence during the testimony a bad look, especially in front of the jury?
I think it's always a bad look when the defendant, or in this case, the defense in a civil case, doesn't show up, because the jury doesn't want to show up either, right? They're taking time out of their life and they have to come. And so it's definitely disrespectful, but they're not going into liability, which maybe could have hurt him a little bit more. I think the only place where maybe this will come into play is punitives, because punitives you could almost think of as like a sentencing version of the civil versus a criminal case. It's where you take into like deterrence, and him not showing up, the jury might think he needs a higher punitive award to deter him from taking this action because he's not taking it seriously by showing up.
Yeah, and it's not like in other cases where the person has no ability to reoffend. He actually does. Terry, as we listen to the plaintiff's attorney doing their direct examination on the family members, are there specific points being emphasized?
No doubt about it. I do think the plaintiff's attorney is trying to weave this sort of story with each and every family member and each and every person who gets up on that stand, you know, the testimony is emotional, no doubt about it. And he does want the jury to feel that emotion. And beyond that, he definitely wants to make sure that the jury knows who those family members are. Where did they go to school? Where did they grow up? How were they attracted to each other if it's a husband and a wife? But he also wants to make sure that that jury understands the victims. So not only do they explain themselves and what they're going through, but they explain those victims, those babies who were shot and killed at the ages of, 6 and 7. And so he makes sure that the jury hears that and that each of those family members tell the story about their individual child and while their child was very special. And basically, when the families learned about Alex Jones, that's one thing the plaintiff needs to make sure the jury understands. How was it you heard about the hoax? What was the effect of that hoax on you? How did it affect you emotionally, physically, financially? And you heard the story. So Alyssa Parker and Robbie Parker told about how it affected them, and it was powerful.
Absolutely agree wholeheartedly in all of that. Well, Dina, Terry, thank you very much. And thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.